The aftermath of a data compromise is a period defined by intense legal and financial scrutiny, where every previous decision and every subsequent action is weighed against the standard of professional care. Today, we are learning how to limit your organization's legal liability after a data breach has been identified by utilizing a combination of rigorous documentation, expert counsel, and pre-established technical controls. Typically, the goal of a liability management strategy is not just to resolve the technical incident, but to demonstrate to the court and to regulators that the organization acted as a responsible and diligent steward of the data. In practice, liability is the formal legal responsibility for the specific harm caused to individuals or other businesses as a result of the unauthorized disclosure. What this means is that we are building a defensive file that proves the organization met its professional obligations before, during, and after the crisis occurred. Before we continue, a quick note. This audio course is a companion to our course companion books. The first book is about the exam and provides detailed information on how to pass it best. The second book is a Kindle-only ebook that contains 1,000 flashcards that can be used on your mobile device or Kindle. Check them both out at cyber.author.me in the Bare Metal Study Guide series. A foundational requirement for a successful legal defense is the professional practice of documenting every single step of your internal investigation in real time to prove that the organization acted with total due diligence. This record must include the exact time the anomaly was discovered, the specific technical steps taken to contain the leak, and the names of every individual involved in the decision-making process. In practice, an evidence trail that is created during the event is far more persuasive in a courtroom than a report written weeks later from memory. Typically, a judge or a regulator will look for this objective history to determine if the company's response was reasonable, timely, and aligned with industry standards. What this means is that your administrative discipline during the chaos of a breach is the primary mechanism for protecting the company's long-term legal and financial standing. A major and potentially devastating pitfall in the early hours of an incident is the tendency for leadership or technical staff to make definitive public statements about the cause of the breach before the facts are fully known. If an organization prematurely blames a specific vendor or claims that no sensitive data was taken, and the forensic evidence later proves otherwise, the organization's professional credibility is shattered instantly. In practice, these inconsistent or inaccurate statements can be used by opposing counsel as evidence of negligence or an intent to mislead the public and the regulators. Typically, the most resilient organizations maintain a strict silence on the technical specifics until the legal and forensic teams have verified the ground truth of the situation. This realization highlights why a controlled and coordinated communication strategy is a non-negotiable requirement for limiting your organization's overall liability. You can achieve a significant and immediate quick win for your financial protection by involving your cyber insurance carrier early in the response process to verify your coverage and your specific notification requirements. Most modern policies include first-party coverage for forensic investigations, legal fees, and the cost of notifying affected individuals, but this coverage often depends on using pre-approved vendors. In practice, failing to follow the insurer's specific protocols or missing their reporting deadlines can lead to a denial of the claim, leaving the organization to pay millions of dollars in costs out of its own pocket. Typically, the insurance carrier also provides access to specialized breach coaches who can guide the executive team through the initial legal and administrative hurdles of the crisis. What this means is that you are treating your insurance policy as a strategic resource rather than just a passive financial safety net. It is worth taking a moment to visualize a comprehensive and professional legal defense where you can clearly show that your organization followed all established industry standards and legal requirements for data security. In such a scenario, the defense team presents a documented history of regular security audits, updated software patches, and a robust encryption strategy that was in place long before the breach. Typically, this evidence demonstrates that the incident was the result of a sophisticated and unavoidable attack rather than a failure of the organization's internal controls. In practice, a company that can prove its good faith efforts is much more likely to receive a favorable settlement or a reduced penalty from a regulator or a judge. This visualization helps us see that your daily commitment to technical excellence is the ultimate foundation for your organization's legal resilience. In the specialized field of privacy law, we often use the term safe harbor to describe specific legal protections or reduced penalties that might apply if the organization had implemented certain recognized security measures. For instance, several state laws in the United States provide a safe harbor from certain types of lawsuits if the organization follows a specific cybersecurity framework, such as the NIST, National Institute of Standards and Technology, Cybersecurity Framework. Typically, these protections are designed to incentivize businesses to adopt high-quality standards by offering them a layer of legal immunity or a presumption of non-negligence. In practice, knowing which safe harbors apply to your specific industry allows the organization to prioritize its security investments to achieve the maximum possible legal benefit. What this means is that you are using your technical architecture to create a formal legal shield for the entire enterprise. Reviewing the specific liability limits and the indemnification clauses in your third-party vendor contracts on a regular basis ensures that you can recover your costs if a breach was actually caused by their technical or administrative failure. In the modern cloud-based economy, many breaches occur at the vendor level, yet the primary organization remains the one responsible for notifying the individuals and dealing with the initial fallout. In practice, if your contracts are poorly drafted, you may find that you have no legal way to force the negligent vendor to pay for the damage they caused to your business and your reputation. Typically, a seasoned professional works closely with the legal and procurement teams to ensure that these risk-shifting clauses are strong enough to protect the organization's interests. This level of contractual oversight ensures that the financial burden of a breach is shared fairly by the parties who were actually at fault. Imagine the immense and undeniable value of having a perfectly documented history of regular, high-quality security audits and comprehensive staff training sessions during a multi-million-dollar class action lawsuit. When the opposing side claims that the company was reckless or indifferent to data security, these records act as a powerful and objective rebuttal that proves the organization's ongoing commitment to professional standards. Typically, a history of consistent training shows that the company took reasonable steps to prevent the human errors that often lead to unauthorized data disclosures. In practice, the absence of these records is often interpreted by a jury as a sign of a lazy or neglectful security culture, regardless of the actual technical tools in place. This scenario highlights why the boring administrative tasks of logging and tracking are actually critical components of your organization's long-term legal defense and survival. Every professional strategy for breach management should be anchored in the fundamental need for a defensible and well-documented response that follows the specific legal advice provided by your specialized counsel. This means that the attorney-client privilege should be established as quickly as possible to protect the candid discussions and the preliminary findings of the investigative team from discovery by the opposition. In practice, the lawyer should be the one to officially hire the forensic firm, ensuring that the resulting reports are treated as privileged work product created in anticipation of litigation. Typically, this legal structure allows the organization to investigate the root cause of the breach thoroughly without creating a roadmap for a future plaintiff to use against them. What this means is that you are using the rules of the legal system to provide a safe and professional environment for your technical and investigative work. We have now discussed the critical role of legal counsel and the absolute importance of maintaining a continuous and accurate evidence trail to protect the company's interests after a breach. By building a robust and practiced framework for managing liability, the organization is taking a significant step toward achieving a more mature and resilient information governance posture. Typically, the most effective programs are those that view liability management as a cross-functional responsibility that involves the technical, legal, and insurance departments in total lockstep. In practice, this integrated approach ensures that the organization remains a trusted and reliable participant in the global digital economy, even during its most challenging and high-stakes moments. This commitment to defensibility is what transforms a simple incident response plan into a high-performing and business-aligned governance engine. A highly effective and essential technique for limiting liability is the use of robust encryption as a primary technical control, as many global privacy laws significantly reduce or even eliminate the notification requirements if the stolen data was properly encrypted. For instance, under many statutes, a personal data breach is legally deemed not to have occurred if the records were protected by a recognized cryptographic standard that remained uncompromised. In practice, this means that if an encrypted laptop is stolen, the organization may not have a legal duty to notify thousands of customers, saving immense amounts of money and reputational damage. Typically, this safe harbor for encryption is one of the strongest arguments for implementing full disk encryption and database-level protection across the entire enterprise. What this means is that you are using mathematical engineering to fundamentally eliminate a major source of organizational and legal risk. Limiting liability effectively requires a sophisticated combination of proactive technical security controls and a highly disciplined, legally led response after a specific incident has occurred. When the organization's practices are transparent and its records are impeccable, the business can defend its actions with total professional confidence and certainty. Typically, a mature program uses these standardized workflows to ensure that every security decision is made with an eye toward how it will be viewed by a regulator or a judge in the future. In practice, the energy you spend on perfecting your documentation and your insurance protocols today is a direct investment in the long-term legal and financial health of the entire enterprise. This focus on defensibility is what ensures that your governance program remains a verified, trusted, and highly effective reality in the modern digital world. This session on the essentials of limiting breach liability through documentation, counsel, and controls is now complete, and you have gained a solid understanding of how to protect your organization after a crisis. We have discussed the definition of liability, the role of safe harbors, the importance of involving insurance carriers and legal counsel, and the value of encryption as a primary liability reducer. A warm and very practical next step for your own professional growth is to take a moment today and check your organization's current cyber insurance policy for any specific and time-sensitive notification requirements. As you read, consider whether your current incident response plan is aligned with these insurance mandates and who the primary contact person is for starting a claim. Moving forward with this observant and disciplined mindset will help you ensure that your organization's digital truth is always safe and fully defensible.
Thanks for listening. For more audio courses, daily newsletters, and more, please visit BareMetalCyber.com.